Hi, I'm Angela Jin, a PhD student at UC Berkeley, and I'll be presenting work done with my collaborator, Dr. Niloufar Salehi, on understanding challenges that public defenders face in scrutinizing AI in court. In 2016, Mayor Herskovich, a Hasidic man living in Williamsburg, was convicted of a violent assault. The forensic lab involved in this case used a probabilistic genotyping software, a type of AI system widely used in forensic DNA analysis, to analyze a DNA sample obtained from the victim's sneaker. The software's output concluded that DNA found in the sample likely belonged to Herskovich, and this incriminating evidence played a pivotal role in his conviction. However, no other physical evidence linked him to the crime, and the software tool used in this case was never tested on a population as genetically insulated as the Hasidic Jews of Williamsburg. If you were in this situation, knowing this, what would you do? In Herskovich's case, he and his lawyer contested the decision. In 2018, Herskovich's lawyer appealed his conviction, contesting the reliability of this AI system used in his case. A key argument in their appeal highlighted insufficient evidence about the software's reliability in settings similar to this case. Herskovich's story exemplifies growing calls in HCI, responsible AI, and law to make AI systems contestable or open to scrutiny and disagreement, as AI systems are increasingly used to make decisions in high-stakes domains such as criminal law, healthcare, and housing. Numerous scholars have argued that doing so can promote fairness and accountability, protect individual rights, and prevent or mitigate harm in decision-making. Recognizing the gap between principles and practice, a growing body of work in HCI seeks to operationalize contestability, providing frameworks and insights for designing contestable AI. These efforts to support contestation in practice often refer to documentation about AI systems' performance, therefore raising the following sub-question: how can performance evaluations support contestability? To this end, a growing body of work in HCI and responsible AI investigates how to design evaluations and evaluation tools to engage diverse stakeholders and address their needs, what to communicate about model performance, and how various stakeholders might interpret this information. In our work, we seek to expand both of these efforts by focusing specifically on public defenders' efforts to contest the reliability of the U.S. government's use of computational forensic software, or CFS. We use the phrase computational forensic software as defined in the Justice in Forensic Algorithms Act of 2021 as any software that relies on an automated or semi-automated computational process to process, analyze, or interpret evidence. In our paper, we focus on facial recognition systems and probabilistic genotyping software as two examples of CFS. Facial recognition, which has already been adopted by more than 3,000 police departments in the US, is often used to help identify individuals captured in an image by comparing the probe image against a database of images of faces with known identities. Probabilistic genotyping software, which has already been used in over 380,000 cases worldwide, is often used by forensic labs to compare the genetic profile of a person of interest against a DNA sample obtained from the crime scene, typically when the crime scene DNA is deemed too complex for manual interpretation. We situate our study in the U.S. criminal legal system, which relies on an adversarial system in which the prosecution is tasked with proving guilt, while the defense is tasked with disproving the prosecution's case. In the context of CFS, we focus on scenarios in which the prosecution introduces a CFS output as evidence of guilt, which the defense may seek to contest in front of judges and/or jurors. We specifically ask, what challenges do public defenders face when scrutinizing and contesting the reliability of the government's use of CFS in the U.S. criminal legal system? To this end, we conduct a series of semi-structured interviews with 17 individuals in the U.S. public defense community, focusing specifically on public defenders and individuals who work with public defenders on technology-related aspects of cases, such as technologists working in public defense offices. In the interviews, we focus on participants' past encounters with CFS and casework, how they attempted to assess and contest reliability, and challenges they faced in doing so. For the remainder of the talk, I'll discuss each of these in more detail, starting with the select findings from our paper. We organize our findings around 3 categories. First, we find that CFS developers, which are often private companies, and users, such as forensic labs, police departments, and prosecutors, can prevent or severely limit defense scrutiny by limiting information or paths available to public defenders. Additionally, we find that defenders must overcome judges' and jurors' non-critical perceptions of CFS to convince these key decision makers to act on public defenders' efforts to contest CFS. When navigating many of these challenges, our participants frequently relied on working with others with relevant CFS expertise, such as outside experts who could help defenders develop strategies and testify in front of judges and jurors. However, our participants described a range of difficulties gathering this relevant CFS expertise. In our paper, we discuss numerous types of challenges within each of these categories. For this talk, I'll share a few illustrative examples from each. Starting with the first category, we find that whether CFS users disclosed CFS use in a case could prevent public defenders from even knowing that a CFS tool was used in the case at hand. Sometimes CFS users proactively hid their use of CFS from the defense. In the case of facial recognition, participant 13 described how police often just hid the fact that they used facial recognition completely and created these parallel constructions where you wouldn't understand how they got from no suspect to suspect. Even if public defenders knew the government used the CFS in a given case, how CFS users use the CFS in the case can preclude defense scrutiny or contestation of the CFS tool. Participant 15 described this in the context of facial recognition, saying, there are certain types of motions that you only get to file if, for example, evidence is going to be introduced in a case, and the facial recognition results aren't going to be introduced, right? What's going to be introduced is the eyewitness identification of somebody picking your client out of a photo array. So basically, you don't get to challenge that earlier stage, is how law enforcement and prosecutors tend to frame it. We further illustrate this on the left with the simplified timeline of a criminal case. In this quote, participant 15 described a scenario in which the police do not hide the use of facial recognition, but instead use facial recognition as an investigative lead. This means that police may use facial recognition to identify someone as a person of interest, place that person's image in an array of photos that an eyewitness then examines, and then arrest the individual identified by the procedure. As P15 described, this procedure is then the only evidence introduced in court, and law enforcement and prosecutors are saying that public defenders could not challenge that earlier stage since facial recognition was only used as an investigative lead. Participants contrasted facial recognition with probabilistic genotyping, which is typically introduced as evidence and can consequently be subject to motions contesting the reliability. Moving on to the second category, participants felt that judges were often overly deferential to prosecutors and police. When asked how courts had reacted to their efforts to contest the reliability of facial recognition used as investigative leads, participant 4 responded, most courts have not agreed with that argument. But the reality is, most trial court judges are terrible to begin with. They're very pro-prosecution. Participant 13 describes how judges' deference to law enforcement may prevent them from being critical of CFS, saying, when you're talking about tools used by law enforcement, if a judge here were to suddenly turn around and say, wait, there's something really wrong here, you can't use this, that means they're pitting themselves up against the entire police department, and it's a political position. They are appointed judges. They just might not get appointed again if they make it impossible for law enforcement to use this tool that law enforcement has claimed is necessary for them to do their job. Participants also described how judges and jurors' difficulties understanding statistics could prevent these decision makers from critically examining CFS and statements about CFS reliability. Participant 15 discussed this challenge when reflecting on what they perceived to be the inevitable disagreement between defense and prosecution over how to define false positives and false negatives and which types of errors to prioritize, saying, You have to come up with a definition for what qualifies as a false positive or a false negative. And there's a lot of disagreement, right? There's going to be a lot of debate. But judges are not statisticians, and so they get a little lost in questions like, what is the difference between a false positive and false negative, and why would we be more concerned about one than the other? Participant 15 also illustrated how judges and jurors may have difficulties differentiating between different types of statistics. In the context of probabilistic genotyping, which produces a likelihood ratio as its output, participant 15 described what they're going to say is, but the likelihood ratio is 800 octillion, and that's a really big number, and I have no idea what that number is, but it's a big number. And so what that sounds like is certainty. As participant 15 described, judges and jurors may conflate likelihood ratios with measures of uncertainty, despite prior work highlighting that the magnitude of a likelihood ratio itself does not communicate certainty. Moving on to the last category, we find that having attorney-analyst liaisons can help public defenders work with experts, but can be costly to implement in practice. Many public defense offices in the US are underfunded, meaning that many offices may rely on defenders to informally adopt liaison roles instead of specifically hiring for formal roles. Participant 5, for example, is a public defender who takes on liaison responsibilities in addition to their own caseload. Participant 5 described, I'm coordinating a lot of forensics in the office, but it's not part of my job. Expanding public defenders' existing responsibilities to include this kind of coordination presents an additional cost. Increased responsibilities to already overburdened, underpaid public defenders. In this paper, we've discussed the following subset of challenges. For a more comprehensive discussion of our findings, please see our paper. To wrap up this presentation, I'll now share some key implications of our work for designing contestable AI, along with opportunities for future work. Earlier, we discussed how CFS uses as investigative leads can preclude defense contestation, even when the CFS tool influence law enforcement decisions to arrest the defendant, since motions that defense could file to contest CFS reliability only applied to evidentiary and not investigative uses of CFS. We also saw how our participants felt that their efforts to convince courts to allow them to contest the reliability of investigative uses could fail due to judges being overly deferential to prosecutors. These findings highlight the importance of closely engaging with interpretations and impacts of policy definitions of in-scope technologies and technology uses, since we see that how policies and laws define what's in scope, how decision makers interpret those decisions, and how those definitions may align or misalign with how technologies are used in practice can either support or prevent efforts to contest CFS reliability. Future work in HCI can further investigate interpretations and impacts of policy definitions in other contexts, assess how they shape contestability, and closely engage with policy design while doing so. We additionally discuss implications for designing evaluations and evaluation tools to support contestation, such as the importance of supporting cross-disciplinary collaboration and skill sharing. In our study, we find that public defenders work closely with defenders in other jurisdictions, attorney-analyst liaisons, and both outside and in-house experts in their efforts to contest CFS reliability. Our findings echo recent work highlighting the need to support collaboration in user-engaged auditing and illustrate collaboration across different types of expertise that future work designing evaluations and evaluation tools should consider. Lastly, we discuss implications for communicating performance evaluations, such as the importance of understanding how deliberation and presentation of performance influence perceptions of reliability. Our findings suggest that deliberation and contestation of performance metrics and other information presented alongside performance may play crucial roles in mediating real-world perceptions of reliability. We highlight these as factors for future work to consider and investigate to further contextualize studies and how people perceive performance results in practice. This concludes my presentation. Thank you for your time and attention, and please feel free to reach out if you're interested in chatting.